Thank you, Mr. Wong, and please remain on stage. May we ask Mr. David Matheson to moderate the question and answer session for us. Mr. Matheson, please.
Well, you certainly see the importance of Hong Kong for the Western world coming here with a strong legal base, absolutely unique, the Western world of Asia in our minds and in reality. Now, you've seen the broad scope I mentioned earlier, that the responsibilities that the Secretary of Justice has, and it's staggering, but it's successful. Now, the floor is open for some questions, and as is the practice, I might lead with a couple, or at least one, till I get some of the notes. Let me have my first question. So important is that foreign companies going into China are concerned, obviously, about intellectual property, enforcement of judgments. And in the last while, the recognition of judgments in Hong Kong in connection with trade or investment matters or on intellectual property, both are court judgments and also arbitration judgments. Would you like to expand on that a little bit? Thank you.
Thank you. As I mentioned, under the one country, two system principle, we are a common law system, whereas the mainland's legal system is different, so we are separate jurisdictions. But as in the relationship with other jurisdictions, we enter into arrangements and agreements with other jurisdictions to enable judgments and arbitration awards to be enforced on a reciprocal basis. So we have been doing that with the mainland, but you have to bear in mind the difference in the legal system. We have in fact signed an arrangement with the mainland on reciprocal enforcement of arbitral awards back in 1999. And we have been fine-tuning that, and that's on top of the New York Convention 1958, where both China and Hong Kong are parties to it in terms of the enforcement of arbitral awards among the member states. And also, we had another breakthrough about, it's in 2006 in terms of the arrangement, in 2008 in terms of the implementation, and that is the enforcement, mutual enforcement of certain commercial monetary judgments of the courts. There are certain conditions which need to be satisfied, like there has to be finality, there has to be some exclusive jurisdiction clause, and so on. Very much modeled on the Hague Convention type of reciprocal enforcement that some of you may be familiar with. Now, so we have achieved that, and then the implementation is taking shape, and we are monitoring that very closely. We hope that that could be a type of a kind of prototype for things to come gradually, dealing with the not so controversial matters first, and then we are now continuing with that. In Hong Kong in particular, you can imagine with the social integration of the mainland, a lot of cross-boundary marriages. Now we are exploring with the mainland in terms of reciprocal enforcement of judgments in the matrimonial context. So apart from all these, I should also mention earlier, Hong Kong is keen to develop our strength as an international arbitration center. Now, we ride on the agreements we have, and we are also in very close cooperation with the mainland's international arbitration bodies. Just last month, I signed an agreement with CCPIT, the overseeing body of CTEC, the mainland's main international arbitration body, to strengthen cooperation between the arbitration bodies of the two places. Now, all these, I can see that Hong Kong is becoming, and I hope, is going to assume a very significant role in the Greater China region as a platform for dispute resolution center. So I hope that we are on very good ground, and then a lot of these will be progressing on the basis of the experience that we have.
Question over here.
Representative from Thailand. Okay. My question is about the competition law. Earlier, you were just saying that you mentioned that freedom also comes with a set of rules, and then you principle of physics, something like that. I think business is not exception, right? They have rule of the game. But I think about 2 days ago, I attended this Legislative Council public hearing about competition law. I was so surprised to hear from the SME Association. A lot of them are against the law. And one of the reasons they're against it because they say they don't want to pay legal fee. They are aware about they are a small company. But it doesn't make sense to me, okay? That's another, because they have some concert activity, they worry it become a cartel thing, like a thing. But I think it's a jurisdiction system. I think you can help to let them understand. But my understanding is the benefit for the SME a lot more than this legal fee issue. And in reality, a lot of cases it's just like warning, kind of not go to legal system, right?
Question?
Yes. This is the first question. What the justice system can do to promote, to educate the SME. Second is we talk about free trade. I understand, I think from all the countries here, they all have competition law in their country. In ASEAN, 4 countries already have a competition law. Malaysia is already passed the law in Parliament, effective 2012. And ASEAN, other countries, including Burma, Laos, Cambodia, they all committed to have competition law by 2015. Everybody knows in the world that
Question, please.
economic efficiency and consumer welfare, okay? That all agree. But I just wonder why Hong Kong do not pass the law. Secondly, all the bilateral trade agreement, they come with competition law as a provision. Why we still arguing about should have the law and not have the law? Okay, this is my second question. Thank you.
Sorry, I didn't quite get the second part of it, but let me deal with the thrust of your question. I think
you can do the first part here and have them come up after.
In fact, the question, the very question you put to me is how we can help the SME appreciate, the merits of the competition law. I think my short answer is to engage gentlemen like yourself, to speak to them, and to share with them about experience in other jurisdictions, that the things that they are worried about did not in fact pose grave obstacles and mischief that they apprehended. I think on the question for competition law, as you said, I mean, other advanced economies, they have competition law. And the objective of our competition policy and law is, of course, to enhance economic efficiency and also to provide level playing field. And the thrust is really to deter anti-competitive conduct, which I think must be good for everyone, including the SMEs. I think what we have to do more, my colleagues will have to speak to them more and also explain the detailed provisions, how it's going to work, and then also allaying their concern by reference to experience elsewhere. There will be unknowns, of course. They will fear about things becoming more litigious and so on and so forth. Some of these things could only be overcome with actual experience. But as far as we can at this stage is to do whatever we can to persuade. But in fact, this piece of legislation was, before the introduction of it, there was already very in-depth consultation with the various stakeholders, and also we've got expert groups examining the positions in other jurisdictions and coming up with the proposal which we believe is the most suitable one for Hong Kong. Thank you.
One question here, which is pretty sweepingly broad, but I will repeat it. What stresses will integration put on the legal system?
Sorry, what?
Integration.
Integration.
Who put this question forward? You want to expand on it?
Sorry, a gentleman down there. Yes, yes.
Hi, Greg Thomas from Thailand also. As Hong Kong and mainland China continue to integrate economically, what stresses will that integration put on the legal system here in Hong Kong?
Stresses, okay. Okay. I understand. I think, as you said, I mean, I have been very careful to say that in terms of integration, there is obviously very strong momentum on the economic integration. And it carries with it, of course, the social integration. I mean, it's something we have to face and tackle. But on the legal side, we emphasize the success of Hong Kong lies on the separate system. You're right that inevitably there will be occasions where the separate identity of Hong Kong might be put to test. And that's why I think what I mentioned about the uncompromising commitment to the rule of law and to what is set out in the basic law will be fundamental. I think we have to take a long-term view. The success of Hong Kong really lies in the integrity of the system. And there will be times when when some of these provisions of the Constitution which laid down the dividing line will be put to test. There will be pressure from the economic side to try to persuade some relaxation on the demarcation or the dichotomy. But I think so far as I'm concerned, my responsibility is very much to advise my colleagues in the government where the line ought to be drawn for the better future of Hong Kong and for China in terms of maximizing the benefit of the one country, two systems.
Question over here.
Sherman Yan from Hong Kong. Earlier on, you mentioned that the government is in the process of reforming various laws in Hong Kong, notably the companies law, the trust law, corporate rescue, and all that. But as a matter of fact, the law reform process in Hong Kong, in my view, is rather slow. And over the years, the Law Reform Commission has published various reports, but very few of them have been implemented. So my question is, what more can we do or should we do to speed up the law reform process in Hong Kong?
Okay. I, of course, am very conscious of that. I'm the chairman of the Law Reform Commission. It is, of course, important for us to give importance to the proposals, the law reforms. But you also have to appreciate that some of these proposals are complex in nature. And also when they are sort of introduced at the consultation stage, there have been responses from the community which raise quite different views. And in terms of on the policy side, in terms of the implementation of these reports, they have to be sensitive to the response of the communities, because if you embark on an exercise where you meet with opposition and there's no chance of actually succeeding, then you will have to think twice. However, I think I agree that there should be greater importance attached to the law reform process. And of course, I keep reminding my colleagues in terms of paying attention and also giving priority in terms of implementation of these reports.
I should add that in Canada it's quite similar, and I'm sure it is similar in many other countries. But what is important is that we keep at it to make sure they advance it. Any other questions? No other questions? Well, that means you gave a lot of answers in your presentation.
Thank you.
And I want to thank you so much for a job well done.
Thank you, Mr. Wong and Mr. Matheson. Now, would our guests please continue to enjoy your meal and desserts? Thank you very much.